right. Welcome. And we are going to talk about essential business contracts and buy sell agreements. And I am joined today by my friends Chad and David, who are going to introduce themselves. So take it away, the two of you. Explain what you
David
do,
Oase
who
here,
you are.
CPA in practice in Tucson for 30 some years. So we help a lot of small businesses and we see a lot of things they do right and a few things they do wrong, of course.
Yeah. Chad Denson, also practice with David here in Tucson. We help small businesses scale painlessly and financially retire from their businesses.
So, and they help me tremendously when I send clients to them as to things that I'm not going to know as an attorney because I don't have CPA after my name. So, our philosophy is the same essentially, and it's that there's no one size fits all for businesses. Like you can't you really need to look at your business and your needs. We focus on education, like having knowledge, making decisions about your business, not just saying like, oh, okay, that's what I'm going to do. Like, know why you're doing it. Doing it correctly the first time saves you time and money. How many times do you guys have to correct things?
It's a common problem.
It's
Yeah,
LLCs not
and
set up, no license, all the things they didn't do.
right. And how much more expensive is that?
a lot.
The whole point of this is you all are small business owners, and running a business is hard work. And we run our own businesses, so we know we just happen to work in this field. And if you can get a team, that's going to save you ultimately time, but also it's going to save you money because we're not in the posture of fixing things, but also it gives you more time to actually do your work that brings you money. So, we highly recommend that you get a good team. So our goals today are to talk about basic contract concepts and what you need to look for in every single deal, and then discuss different types of contracts, common issues, and red flags. So this seminar is for educational and informational purposes only. There is no substitute for obtaining tax and legal advice from your qualified professional, business law attorney, and also tax professional about your personal circumstances, your business in particular. And this presentation is not an endorsement by the host. And with that, let's get into it. So, for every single deal that you do, please put your contract in writing, preferably not on a cocktail napkin, but in writing is actually the way to go. Arizona does recognize oral contracts, but people's memories are not always accurate, even if they're not trying to be fraudulent. And if you don't have it in writing, then you're going to have a harder time enforcing it. And if you do have it in writing, then everybody knows what they need to do. And you are governed by the four corners. That's what we call it, the four corners of your contract. So make sure it says what you negotiated, what you think the terms are, and make sure that it's clear as well. If it does not say what you think it does, or if if there are terms missing, do not sign it because you're going to be stuck with it. And for a long time, there was a car dealer in town that actually gave me a lot of business because they would leave blanks in the contract. So they would leave out VIN numbers and then they would swap VIN numbers. And so someone thought they were getting this car, but really they were getting that car, which is not what they wanted. But they were signing the documents anyway, and they were being told, yeah, 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 we'll put that in. We just don't know what the VIN number is now. Also, if you have a contract, everyone should sign it, and you're going to be stuck with your written contract. So make sure it says what you want it to say. And do you guys have anything to add to that except like, please make sure that it's in writing?
We see a lot of places with no contracts. The biggest sinners are real estate people. We're going to buy this house together, fix it and flip it. And there's no agreement in writing about what's going to happen.
Or who gets what.
Right.
That and there's no, or they form an LLC to do it, and then they don't do an operating agreement. All right. So for every single deal, you should have your business law attorney review it. And your qualified tax professional should review, or vice versa. I'm not sure who's chicken. I'm not sure who's egg, but please do this before you sign the contract. I have people that will, and I hope you guys are all laughing, but it's true. I have people that will contact me and say, "Hey, can you review this contract? We're doing this deal for whatever." And I say, "Most certainly, I'm happy to consult with you." And they send me the contract and they've already signed it. At which point I'm like, "Well, there's nothing we can do about it. Do you really want to know how bad it is or what could happen? Or should we just be surprised and hope we never learn?" Really, you've got to have it looked at before you sign it, because once you sign it, you're locked in. I mean, I actually had in two circumstances in the last month, I've had the parties on the other side come back and want to change the deal after we had signed documents. And it was like, no. And they're like, "Oh, well, we just forgot." Well, no, like we're done. Like you should have thought of that beforehand. So the same goes for you. All right. So when I review contracts, I'm ensuring that there is maximum liability protection. Like, how can I make sure that I protect you and your business? Contract really means. I translate legalese very well. Uh, I try to make, when I'm drafting, I try to make it very clear because I don't see any point to having legalese. I think someone back in 1960 wrote a contract that's like floating around the internet, and then someone was like, "That's cool language," and they add it. If you see anything that says party of the first part, get that rewritten because I don't even know what that means. Um, I also assume the worst case scenario, like that we're going to have to defend the contract or we're going to have to enforce the contract, and what puts us in the best position to do that. And then I verify that all associated documents are created, signed, filed, recorded after the deal is done. Because what I find that happens is everyone gets all excited that the deal is signed, and then they don't do any of the things to memorialize it, like to, you know, record the deed or file the UCC1 financing statement, contact the IRS, and let them know that there's a new responsible party for the EIN. I'm going to let you guys take this one. Qualified tax professional review of contracts.
I'll let you go, Chad. You want to talk about that one we had reviewed a few months back?
As far as minimal tax liability, when we're setting up contracts and operating agreements, I have a client that never set up an operating agreement for their partnership, and then they made an S election. We made an S election, and I advised them very strongly to go and get an operating agreement at that time, and they blew it off for a year and a half. And they're to a point where something that happens in many partnerships or mutual business arrangements where one person is doing a majority of the work and one person brought a lot of the money, and the person who's doing a lot of the work is now really frustrated that the person who brought all of the money is getting paid equally and has started pulling money out of the corporation hand over fist, and there is nothing that the other partner can do about it at this point because they don't have an operating agreement. There's no no way to stop any of that stuff. So when we're talking about the minimizing the tax liability, talking about wages and salaries and distributions and you know that entity structure plan is really super, super important. Also, when we're talking about the equity side, when we're trying to avoid capital gains, we can only take money out of our corporation to the balance of our capital account. Small businesses have equity just like a home does. So when we start a business, we might put $1,000 in it. Equity goes up when we make profit. Equity goes down when we pull out distributions. But we can't pull money out past zero. Otherwise, we not only have to pay tax on all of the income, but we also have to pay capital gains tax. So there's a whole lot of ways that we want to make sure that things are set up in our agreements in the beginning to avoid those pitfalls and then making the accounting important as well.
I think you mentioned to me that everyone can determine what equity they have in their business, if it's on their tax return. Um, Tell me about that.
If their tax return is prepared correctly. But at the end of the day, if you're looking at the balance sheet, there are schedules that are attached to the balance sheet. Schedule M will tell you what your capital accounts are. There's also a 7203 form, and that's really, it hasn't been required. Income and your assets were below a certain threshold. But the problem with that is that you're not tracking your capital accounts correctly necessarily. And if that's the case, you don't know if you're subject to additional capital gains tax, but the IRS does.
Well, and also you guys help when I'm doing buy-sell agreements or an asset purchase. It's like, how do we, what needs to be characterized as what? Like, is it better for us to have a high value for our goodwill or not? Like, what's the ramifications? Um, because that
And
does change tax, yes?
the trick is, who are you representing?
Yeah.
These are designed by the IRS to where the buyer is better if it's done one way and the seller is better if it's done a different way.
Always.
So you have to think about who you're representing and give them the right advice in that regard. The buyer would like all the assets perhaps be allocated to furniture, fixtures, and equipment where he can write it all off the first year. The seller would all rather have it all called goodwill, where he can get the capital gain deduction and the cheapest tax to pay on his tax return. So there's a tug of war there going on between the two.
Well, for sure, if my side has gotten tax advice and the other side hasn't, then it's going to be better for us,
Yeah.
for sure.
Exactly.
So here's my
Exactly.
side note on drafting contracts. She who drafts rules the world. Spend the money to have an attorney draft the contracts. It doesn't cost as much as you think because we all have form banks, but I know exactly where I'm going with the deal, and I'm not necessarily going to tell the other side. And so if you're reviewing contracts, that seems like it's easier, but it's actually not because you don't know the thought process or how they're thinking. And so you actually, in my mind, have to spend a little bit more time working on it. You don't have to have an attorney negotiate the deal. I actually have a deal that I'm working on for a buy sell right now where I'm drafting the documents. My client doesn't think that it will go well with the other side if they know that there's an attorney involved. So right now they just think she's really smart or um and she doesn't want to bring me in um because she thinks that it'll turn into something else, which is fine by me. I like she's gonna have good documents, and if she's able to negotiate, then all the better. I find a phenomenon, and I call it monopoly money. So in one of the deals that I'm doing, and I find this a lot, and I think you guys will probably back me on this, is you're talking about buying a business and you're like, well, I'm going to offer 1.1, and then the other side says, no, I want 1.8. And then you're like, okay, well, let's do 1.5. And I feel like nobody's really like it's monopoly money. Like you're not realizing what is that every single month, including interest. It's like, okay, well, it's 1.1 at 2%. You want 1.8 at 4%. Okay, we'll do 1.5 at 3%. But nobody's asking you guys for the amortization table, and they're
Yes.
not looking at the real money.
Yes.
And so and in fact, one of the deals that I was working on, I was like, yeah, no, we're not going to send our contract over to the other side until we get the amortization table because I don't think you realize what these numbers are. And so I caution anybody in a deal to make sure that what am I paying monthly? Like, what is that number? Because it's in addition to whatever you have to do to run the business. And you don't want to, I feel like everyone gets in this thing like, oh, I'll buy Park Place for $500,000, right? It's not, you're not realizing that you have to actually, send that money and make that money. Do you guys have anything to add to that?
We had a business purchase we were looking at in Covina, California.
That's what I was going to
And
talk about too.
as part of it, we looked at, the purchase was 3 million, the down payment was 500,000, and then the monthly payment was 40,000 a month over 10 years.
Wow. But it sounded like a good idea when you just said it.
It sounded like a great idea until we got to that $40,000 number, and then we just about had a heart attack.
Yeah.
Yeah. And that this deal that I was working on, I mean, it was the same thing. Like when my client saw the amortization table, they were like, I have to pay what per month?
Yep.
Because they were like, well, 4% is a great interest rate. And I was like, yeah, but it's on $1.8 million. Like, that's a big number. It's still doable, but you know, you just need to really be clear about it. I mean, I don't particularly care what you decide to do in your contract. I just want to make sure that you understand it because
Yeah.
it's ultimately your decision, right? I mean, if you wanted to pay, if your client wanted to pay $40,000 a month and they could do it, right on, go for it. Yay! We
And
have a
the other
Thompson
kind of
Covina.
contract that I would touch on here would be that we had a client that didn't make it in business, but who was going out and getting receivables loans. They'd gone to a loan shark and had essentially funds due on a daily basis. They had a $600 a day
Uh,
payment on this receivable loan, and then would go and refinance this for more and more money to where he owed $600 and then $700 and then $1,000 and then $1,500 and literally put himself out of business. And when we would address the other types of loans that we might be able to get and the revenue, they just would put on earmuffs and didn't want to listen and blinders and wouldn't look at the numbers and uh, being really careful and understanding all of the different avenues there are for financing to come up with capital. But yeah, that was devastating, and I've got
yeah, the
another client
sweeps,
who's
the
starting
the
that. But
loans where it's like they sweep every week
yeah,
or sometimes daily.
yeah,
All right. Please get your signatures correct. Please, please, please. Um, I can't tell you the number of times where I'm like, why is, why aren't you using your actual title? And be insistent, like insistent that the signature, block is correct. Like, and use your legal name. I got all the way through doing like four sets of documents for this deal, and my client's like, does it matter that my name is different than what's on the documents? My legal name is really, whatever. And I was like, why, yes, it does. And I'm really excited. I just got these done, but cool, let's do them again. It is so important that you identify yourself appropriately. And truthfully, my example is a little bit bad because if I said Lisa Thompson, that's okay. Um, but my not using my title for either one of my companies is not okay because if I'm contracting for my business, the business needs to be, the tenant. And I need to sign on behalf of the business. All right. If you don't use the correct title, you could break, the shell of your business. So you could be personally liable for the debt of the business if you aren't saying like I'm only signing as the manager. And SBA is famous for that, like not putting in, you might ultimately be responsible for the debt because you sign a personal guarantee and that's okay. But if you negotiated a deal and you're not personally responsible for it, make sure that you sign appropriately. I mean, don't give people another way to come after you unless you agree to it. All right, do your due diligence. Do you guys want to talk about due diligence? Do you have any insight for us
the
aside from do it?
Yeah, I think that the first real estate deal I did took me 3 hours to fight through the numbers to make sure it actually worked. And my third real estate deal took me 10 minutes of these are the basic numbers. Is the payment right? Is the interest rate right? Is the down payment right? Okay, it'll work. So When my best friend came to me, for example, to said he wanted to buy a bar, and I said, they're going to give you two sets of books when you show up to this transaction. He said, what do you mean? I said, well, they're going to give you, here's the tax return we filed with the IRS, and then here's what we really made, the second set of books. And so I warned him that's what he was going to see. And I said, the question you have to ask yourself is, if they're willing to lie to the IRS, why would you believe they're telling you the truth with that second set of books?
The other thing I would mention is from time to time we have people come in, and it happens at all levels. So I have a blue collar worker that has bought a position making deliveries. So he bought the right to work this position. He bought himself a job for like $100,000. And that math doesn't make a lot of sense. I have physicians that will buy the option for a job. So instead of going to work for, one of the local, physician firms, whether it's Banner, TMC, or what, whoever it is, right? ACP, they will actually buy a job, which doesn't make a lot of sense as well. I've seen attorneys want to do it as well. So running the numbers by an accountant and sitting back and does it make more sense to be a W-2 employee? Does it make more sense, to be an S corporation that's contracting? What are you actually buying? You're buying the right to work in this situation with this company? What does that really even mean, right? And having some of those conversations. So running the numbers and not necessarily taking a Fortune 5's word for this contract that you're purchasing.
Yeah, you for sure, you can trust but verify.
Yes.
For me, I am looking at, I go look at the public records. And if you haven't kept your stuff accurate and you haven't been on it with keeping your public records correct, or, your statutory agent is a dead guy, and, not you don't have anything on public record that is accurate and hasn't been accurate for 5 years, then I'm thinking, what else did you not take care of? Because that's the easy stuff. And nobody does it. But if I see the company and everything's accurate and they've had changes, I'm like, whoa, okay. It just adds to your credibility. I'm also looking at, what terminology do you use? And that seems silly, but if you can't do the simple things, then what are you doing with the big things? Like if you're just kind of like, oh, no big deal, nobody cares. Well, then what else are you saying that to? And so I think it's just really critical that you should be doing it anyway. Businesses are not playthings. You need to handle it.
Yeah.
So buy sell agreements. So, as David aptly pointed out, you know, the seller has different interests than the buyer does, right? And we structure these deals differently, and hopefully we meet somewhere in the middle where everybody feels like, it wasn't the best deal, but it wasn't terrible either, because that means you kind of met in the middle. So for the seller, you always want to make sure that there's security in the deal. Like, what happens if payments aren't made? Can you get the business back? Is there any kind of collateral? For the buyer, you want to make sure that time to cure the default. What are your remedies if the seller has said something that's not true? If the seller doesn't do what's promised, like what are your remedies? Transfer of intellectual property ownership. You want to make sure that you're looking at that. What things, can the seller actually transfer the trade name, the website, domain registration, email, phones, all of that. You actually want to do those things, even though your buy-sell agreement says, I've seen it, and I'm sure you guys have seen it, where years and years and years later, it's like, oh, well, we need to change our website, and they have no access to it because they never got the intellectual property transferred to them, and now they can't find the seller. Um, Stock purchase versus asset purchase. I'm going to let you guys reiterate what you said in a second, but basically the difference is, um, when you're we call it a stock purchase. It's buying into the business. It's buying the ownership of the business. So LLCs don't have stock, but it's buying the ownership of the LLC. And you basically step into the shoes of the business owner in their LLC or their corporation. That's a stock purchase. And you're stuck with whatever they had in the past. And then an asset purchase is where you're taking all of the assets, all of the equipment, all of the intellectual property, all of the things that the business has, and you're taking those, you're buying those, and you're putting them in your own business. And so you're basically wiping out the corporation or the LLC or partially wiping it out. So, do you guys have a sense of when a stock purchase, you want to just reiterate what you said earlier about
The
stock purchase, asset purchase?
the stock purchase is better for the seller than the buyer unless a couple of conditions are met. One of my clients just sold their business, and the buyer wanted a stock purchase because he didn't want to have to renegotiate all of the government contracts inside the business. It saved them a lot of time and effort and delays in collecting revenue by being able to buy the stock and take everything over. They did have some other problems though, because the company credit card is still in the seller's name. The buyer hasn't gotten around to moving that to their name. So there's some drawbacks to that process. You have to complete it.
Well, and I think, and there's also tax ramifications, but you brought up a great point. A lot of times people, even though it's not, necessarily advantageous for other reasons. They want the stock purchase, especially if they've got contracts with the government or contracts with insurance companies or those types of things, because they don't want to have to go renegotiate them, send more W-9s, all of that kind of stuff. And so that's when you see stock purchase agreements where they're buying into the LLC because they just step in.
For smaller businesses, buying the assets gives you the best tax deduction. So we loved having you just buy the assets of the business. We can depreciate, write things off quickly.
Well, and you start clean,
Yeah.
right? You form your own business and you don't have to worry about there's a lingering tax liability or hey, welcome to that audit.
Yep.
How quickly are they doing audits now?
It's a
Okay.
slow process. It's mostly computer based. It's very rarely an iris agent.
Well, that's nice.
Hmm.
It's bad for the movies though. It's less sexy, right?
Yes.
Yep.
All right, if you're doing a buy-sell agreement, you have to notify the taxing authorities in whatever way, shape, or form your deal takes. I can't tell you the number of times that there's a stock purchase agreement and it all gets done and nobody notifies the IRS that the responsible party for the EIN has changed. Um, and that's a problem if your new owner, if you're the seller and the new owner doesn't do what they're supposed to, you're responsible for the EIN.
Yes.
If you've got, you know, if you're changing their sales tax, if it's being transferred or it's closed out, like if you sold all your assets, you need to file your final return. Otherwise, it'll come back at some time that is really inopportune for you. Um, Anything else on this, gentlemen?
I've almost never seen someone contact the IRS to change that responsibility for the EIN. It's kind of terrifying to watch.
Um, I am insistent on it. And someone called me out and they were like, we never do this. And I was like, well, we're doing it because my client isn't going to get contacted by your client, by the IRS because your client didn't do something right. And they're like, my clients can do everything right. And I was
Yep.
like, okay, well, then we're going to change it anyway. I
Yep.
was kind of blown away by that.
Yep.
Um,
And I can, depending on where you're at in the process, I've got a client who has sold the business but hasn't transferred the EIN. And he's doing so because he doesn't trust that he's going to get all of his money. He's been carrying the note essentially while this has all been going on. And in the meantime, they're not paying payroll taxes timely. They're not paying income taxes timely. It's a C corporation. There's a lot of additional problems that are coming up. And it's been fascinating to watch. It's been fascinating to watch. There's a lot of problems that are still continuing that he's having to deal with 4 years after selling this business.
It's so important.
Yeah.
It's so important. All right, so we're going to kind of leave the buy-sell world and we're going to go talk about commercial leases, which in my experience are always pro landlord. Um, I really haven't ever seen one that was like, yeah, they were always just very slanted towards the landlord. Sometimes I see them where they're less slanted to the landlord, but generally they're pretty slanted. Be sure the tenant is your business and not you. I just had some clients who, and sometimes you're in the process of forming your business, so you'll get the lease and it'll have your name on it, because you're in the process of getting your business up and running, and so you haven't formed your LLC or your corporation yet. Um, you need to swap that out. Now, the landlord is probably going to say, well, you need to have a personal guarantee, but which they're going to request. But if the commercial lease is in your name, well, then that's the ultimate personal guarantee. Like you're the one that's responsible for it. So just understand what your personal guarantee is. Sometimes you can limit a personal guarantee. So if do need to break the lease or your business is failing and you can't pay the rent, um, you're personally going to have to pay for your business if it can't make the rent payments. So a lot of times landlords are just trying to protect themselves, right? They want to make sure that if it's a new business that they have a way to know that they're going to get rent. So that's why they do the personal guarantee. So sometimes landlords can be talked into, all right, so if we make timely payments for this period of time, we're going to limit the personal guarantee, or we're going to cap the personal guarantee at 6 months of rent or a year's worth of rent. So sometimes there's things that you can do. Um, again, understand the money that you will pay per month. It's not just the base rent. So I had clients come to me this week and they're like, we just got this great lease. And I was like, awesome. And they're like, please review it. The their base rent was in fact awesome. It was like 2 grand. And they're like, we're only gonna have to pay 2 grand. Um, a month for the space. And I was like, do you know what a cam charge is? And they were like, no. And I was like, well, that's common area maintenance within the shopping center. And your percent of that is 18%. So when they go repave the parking lot, you're going to pay 18% of that cost. Um, you're going to have to get insurance. So, your landlord is requiring $1 million in this insurance, this other type of insurance, et cetera, et cetera. Um, the HVAC, sometimes leases require quarterly maintenance so that the filters get changed. There's other annual maintenance that you could be responsible for. Some leases, if you're not careful, you have to replace the HVAC unit on your location if it goes bad. It is so important to look at all of this. And commercial leases are 30 pages long, and I got to get out my magnifying glass sometimes. And I skipped triple net. Triple net is basically you're paying your base rent, you're paying all of the insurance on the property that your landlord is paying. So you get a portion of that as well, and any of the rental taxes that your landlord would have to pay, in addition to real property taxes. So all said and done, my client is going to be paying about $5,000 a month. And I think that's on the low end because we didn't have a quote on insurance. So again, it's about like it's cool that your base rent is low, but you need to look at all of these other things. Gentlemen, do you have something to comment on that?
We have about 100 of these things out at the airport with hangar owners and all commercial leases with all of these complications. And we have a lawyer who specializes in setting them up, taking them down, setting them up, taking them down, because they're 30-year leases. It's so critical that people understand what's going on inside that thing. And because I'm the one billing them afterwards, and they're going, "What's this for?" That's the cam charges.
Well, and that's the other thing. I don't know if the next slide addresses it. Um, but I had the situation just this year where my client, the CAM charges for her commercial lease every year it had been every month had been about $1,000. And then at the end of the year, she got a bill for $10,000. And that was the reconciliation. So what your landlord does is, you pay X amount per month, but at the end of the year, they're allowed to reconcile everything and say, oh, well, you overpaid, so we'll apply that to next month or next year, which never happens. And they don't apply it to rent, they apply it to your CAM charges for the next year generally. Or alternatively, they're going to say, hey, you owe us money and got a $10,000 bill. And we questioned that, but the lease didn't say that we could get any records for that. And it didn't describe what the CAM charges could be, or at least they were very broad. And I will tell you, because I looked at Arizona case law, it is silent as to what CAM charges can be and what happens if you're going to have to challenge them. So, um, it's very important to look at these things and make sure that you're going to have the ability to look at them and to challenge them. David, does your lease allow your tenants to take a gander?
No, I
Well,
just
you're the
provide the
landlord.
accounting. I'm the
I mean,
landlord. I provide the accounting if they ask, but I'm not
right,
the.
exactly. So good job. Nobody's
I've
actually looking at them.
I've
Or
also
you're the only game in town, so they have to do what you say.
I've seen some nightmares where, in multi-unit buildings where multiple units were for sale, you have a new tenant, a new investor comes in and starts buying up individual units to where they have an ownership majority and then start forcing the other owners into these very large CAM improvement projects that sometimes they can't afford. So being really cognizant of what's going on with the other units, if you're in a partial share of a building, can be really important. I've had clients forced out of their commercial real estate. So they literally could not afford the small percentage of improvements that were going to be coming down the pike shortly.
It's true. So again, it's educated decisions. All right. Terms and conditions for websites. I had someone contact me recently, and say, I was told I need these. I don't think I do. You need them. Gonna, so I don't know if that person's on the line. You definitely need terms and conditions. It sets the rules of engagement for anybody using your site. They're really for your protection versus for anyone else. We live in a litigious society, so you need to make sure that you're saying like, hey, if you're using our website, these are the things that, we provide. We do not provide these other things. Like the big thing for me is I'm not giving you legal advice, right? We do not have an attorney-client relationship. If you go on my website, you want to read my blog, that's awesome. You want to make a decision based on my blog, good for you. I'm not your attorney, and that may or may not apply. You want to read my frequently asked questions. They are for informational purposes only. I hope I give you some information, but you really need to talk to me if you want to get that relationship, which I'm sure you guys have the same thing. We're not giving, I mean, it's just like today, we're talking, you know, and we're saying true statements, but we're not saying like, go do this. And so you definitely want to have terms and conditions for your websites. Especially if you're having people join in, you want to be like, this is when we can terminate your account. This is what we do. You want to limit your liability. And also what jurisdiction governs your website. Because if someone's grouchy with you in New Jersey and you haven't said, they might make an argument that they can sue you in New Jersey. And by the way, you sign terms and conditions all the time, like all the time, and you probably don't even read them. This is my job, and I'm gonna confess my sin. I need Microsoft. So when it says we're changing your terms and conditions, I kind of decide I'm just going to be surprised. Like I don't actually read them, because I need whatever the thing is. And so, you know, just like with insurance agreements, I'm going to read my insurance policy when I need it. I mean that's the reality. If we had to read the 30 pages, um, of terms and conditions for every single website that we are a part of, we wouldn't have any time to do anything. So you do sign them all the time. And if you do read them, they're pretty draconian. Um, I actually needed to find, um, I was doing a side note project that had nothing to do with the law. I was trying to be funny about something, and I wanted to do like fake terms and conditions for Santa Claus. And I was like, what would be the most draconian terms and conditions possible? Because I don't want to rewrite these. And Microsoft won that contest, and so I changed them for Santa. Um,
Nice.
Anyway, all right, privacy policies for websites. You need them. You especially need them if you're doing anything with California. You certainly need them if you're doing anything with Europe, because there's heavy duty legal ramifications if you do not. Given it's the internet, you should have them even if you're like, I don't deal with anyone in California. How do you know? It's the internet. So you definitely want to put them in. It's pretty common to know or to get a privacy policy that would be compliant with both California and Europe. Um, you want to also have transparency with your customers. Are you selling data? Are you not selling data? Are you keeping everything confidential? And you want to let them know all of those things. And you agree to these all the time. Sometimes you know about it and sometimes you don't. All right, customer contracts. You can create a template. You should review and update it annually at minimum. Um, Also be ready for your contract to evolve over time. As you identify issues, it happens to me, like my fee agreement, I can look at it and go, that's the Garcia clause. Oh, wait, this is where I forgot to anticipate the thing that happened in the Smith case. Um, and so I've had to add to it because I had missed things. So you can work on a contract all day long and think it's the best contract ever. And there's probably something you missed. There's probably something that you look at a week from now and you're like, oh, I could have said that better. I do it with contracts with clients. In fact, I just had a big meeting with some clients. We've been working on some documents, and we all agreed that we cannot look at them anymore. So we are taking a break for a week because we don't even see them. My clients read them 5,000 times, and we just need to step away so we can look at them fresh. So that's what you want to do with your contracts, and be willing to make changes to them. It's not a one and done. And if you have contracts from 10 years ago, you definitely need to look at them. Um, if you are told that you must sign the contract immediately and you do not have time to contact your tax professional or your attorney, no, like, no, there's something going on. If you ask why and they don't have a reason other than we just want to get this deal done, there is something going on. Would you guys agree?
Timeshares.
Timeshares, yeah.
Timeshares, that would be one. I mean, there's a bunch where my clients are like, I need you to review this. I have to sign it in 24 hours. And I'm like, why? And they're like, because they want to. That is not a legitimate reason.
Mhm. Also, it happens a lot with really high interest rates, predatory loans on vehicles, 27, 30% loans. Hey, we're going to give you this amazing deal on this car. I charge you 30% interest on it. Gotta
Yeah,
act
someone
quickly
wants
because they
to.
get 5,000 off.
I've got a bunch of predatory lenders. Like somehow they got my phone number, and I'm surprised I forgot to turn off my landline. So I'm surprised we didn't get a call. And they're like, call us today. We are just ready to close on the deal to give you financing. And I'm like, probably it was a website where I agreed to like not, to allowing someone to sell my information or the terms and conditions. And so now I'm on some list. And it's like, but you got to call now, you know.
The one I didn't like was the business purchase in which they wouldn't tell her what the price was. 5 days before closing, we'll have the exact price calculated by then, 5 days before closing.
Yeah, no. If you are having, I mean, it's like if you go on a first date and it's bad, don't continue that, right? It's like if it's bad at the beginning, it's not going to get better. Anything else on this one? This drives me crazy.
Yes.
Yeah.
And the other thing, I mean, this is a side note for attorneys and CPAs everywhere. Um, your lack of planning is not going to translate into my urgency, right? Like if you've got your document, contact me because I have other clients and other things going on. Just because you waited until the last second doesn't mean I'm going to drop everything and do your contract.
Right.
That's also a red flag for me, quite frankly. If if you are a new client and you're like, I got to do this and we got to do it in 24 hours,
Yep.
I might not take you as my client.
Yep.
Um, so,
Yep.
all right. It is not a defense. If you get into a contract and you're like, I want to get out of this contract, I didn't understand the terms. Sorry, too bad. It is your responsibility to find out what the terms mean. And this also goes for, if I was living in Mexico, I speak Spanish and I can read Spanish. Probably need to hire a translator to read my document and
Absolutely.
make sure that I understand the terms. So if you are signing something in another language, even if you think that it would behoove you to make sure that you are really, I mean, one, you need an attorney. But two, you need to make sure that you understand all of the terms because you're stuck with them. The other thing that you cannot say is the contract is unfair. It is a well-established legal precedent that we will enforce stupid contracts. The law does not make a decision on whether or not the deal was fair, or you made a stupid deal. Now, clearly, there are some things about that, but like if you negotiated a deal and you decided to pay $5 million for the right to work at Circle K, no one's going to, you can't say, well, this was really unfair and it was completely stupid and I shouldn't have done it. I can say, like, you signed the contract. Like, and you can't say, I didn't understand the terms because you're responsible for that. You also shouldn't be contracting when you're drunk. That is not a defense. Like, hey, I had a bunch of cocktails, so they caught me. I was joking about that at the beginning, like, don't do your contract on a cocktail napkin. I get most of my stories from cases, so
It
just
happens.
saying. I had
It
to
happens
keep
a lot.
that cocktail napkin in a Ziploc bag to protect it. Let's talk about some horror stories. The uh-ohs.
I've got two I can share that I think are reasonable in this regard. We have a three-person accounting firm, 40-year-old, 50-year-old, 60-year-old. 60-year-old says, I want to retire. So he optioned their buyout provision where they were going to pay him a certain amount of money over 3 or 4 years. A year into his retirement, the 50-year-old partner fell over dead from a heart attack. And the 40-year-old says, there's no way I can pay out both of you at the same time. So they met, they talked to their attorneys. The 60-year-old came back to work for 3 or 4 years until they bought out the 50-year-old partner, the deceased partner. And then he proceeded to retire and receive the rest of his buyout. So sometimes the best laid plans of men and mice, you're going to have to work around them. With mine, the one that went wrong, it's a rental property, just like I was talking about, real estate deal with 3 or 4 partners and no contract. And we got into about 6 months into construction and realized one of the partners wasn't doing any work. We had the sit down, come to Jesus moment, if you will, if you want to call it that. And what are you going to do? How are we going to make this work? And so we ended up writing him a $17,000 check to get out of the partnership, even though he never put any time or money into it. So that mistake cost us a good chunk just to make it go away.
Well, and here's the thing too. I've had the circumstance where it is critical to have a buyout. Like if you're going into business with another person or another business, you gotta have that exit strategy. You gotta have how are you going to value the business? Because whoever's leaving is going to value it high, and whoever's staying is going to value it low.
Yep.
Even
Period.
father and son, even father and son, it's terribly important. We
I
had
was going to tell
this
that
blow up.
story next. You've been telling all my
Go
stories
for it.
today. Go ahead, tell my
All right.
story.
So the father wanted to retire and that I own half the business, you do all the work, son, and I'll continue to collect half the profits. And he was very happy with this retirement arrangement.
But it was a generational arrangement. It had been happening for several generations, not just.
Not just him. The grandfather done the same thing. So suddenly the grandson says, I don't like this deal. I don't like the way grandpa and you did it. I don't think that's fair. You're not working anymore. Why should you get the profits?
Yeah. One of my most quoted lines, I don't know if he knows it or not, but one of the most quoted lines around buy sell contracts, I heard from a conversation from David when he was having a conversation with a client. And it was, if both parties leave the table unhappy, you've reached yourself a good deal, right? It was a fair deal. If one person is too happy, it's unfair. Same thing, vice
That
versa.
is,
Party should leave unhappy.
yeah, that is 1000%. We say it for settlement conferences.
Yep.
Like a good settlement is where everyone, but they're not like raging, right? Like just nobody's really like, oh, I got them, right? Just everyone's kind of like, okay, we're done. Great. We can all live with this.
Yep.
And there have to be times and profits for this thing to actually work if you haven't funded it with life insurance.
Yep.
As we saw with the US Supreme Court last year, when they struck down that bad deal, they funded their buy-sell agreement with life insurance, and the Supreme Court says, but you have to pay tax on it. That life insurance is going to be included in the value of the company, drives up the value of the company, and they ended up owing an extra $800,000 or $900,000 in estate taxes because of it.
Ow.
So planned to do it right, didn't realize necessarily all the consequences of their arrangement, what it meant.
Yep.
Fortunately, the cash was there for the buyout. Now, if the drawback is if you're in your 50s and you want a big buyout and the business can't afford to write a quick check, you may not qualify for life insurance anymore. You might have to be a little more creative about how you're going to work the financing of the buyout.
Well, we're at the top of the hour. I'm going to leave you with this. All of this is interconnected. You really, really, really need to have a qualified tax professional look at your deals. You really need to have a qualified business law attorney um, look over your documents and make sure that you are protected because when it goes bad, it goes really bad. Like litigators, if I had someone who was a litigator, an attorney here that was a litigator, they'd be like, don't talk to Lisa, don't talk to Chad and David because that's how I make my money.
Right.
Because litigation happens on the definitions. What does this mean? Wait a minute, that wasn't in the contract. Or, all of that stuff is how you get involved in lawsuits. And those are expensive and those, can take down businesses. So on that happy note, um, Chad and David's information is right here. I only had Chad's email address, but their website, you can reach out to them that way. My information is here. You can go to my website and contact me that way. If you're interested and you own a business, I blog um, every week. So if you're interested in learning what I think are relevant and important business law facts or what's going on in the business law world, please follow that. Look at my FAQs. I talk a lot about buy sells and other business related topics. And thank you guys for joining me today.